Never know when a little problem is going to become a big problem. This is something that we've seen a lot of as a result of the repression. And what I mean by that is, as capital has dried up, meaning the vendor's ability to either factor orders or get lines of credit or letters of credit, they found themselves squeezed and filing for bankruptcy protection. Some of them. Bankruptcy is a lawyer's word for really bad news for unsecured creditors. And my bad news for you guys is sales reps and their commissions fall into the category of unsecured creditors, meaning you don't have collateral. You don't have a hook in receivables. You don't have a hook in inventory. None of that is pledged to secure your commissions. So you fall into the world of unsecured creditors. There are two types of bankruptcies. There's a Chapter 7, which is a total liquidation, where an independent trustee is appointed by the court to take over the company, sell off all its remaining assets at a fire sale, marshal and pile up as much money as they can, and then first pay the secured creditor, meaning the bank, who has a hook or collateral in all the receivables, inventory, and those types of things. And whatever money is left over is split on a pro rata basis amongst vendors and suppliers like you folks. Usually that means, in the context of a Chapter 7, about a nickel on the dollar in terms of what you're owed. There is some good news. Within the scope or the realm of unsecured creditors, some are given priority, meaning if there's $1 million to be split pro rata amongst all unsecured creditors, those that have statutory, what are called priority claims, get paid at least a partial payment as part of a priority, meaning you get the first dollars. Included in that is $12,500 of commissions for sales reps, which is not nothing, okay? So if there's $1 million and there are sales reps out there who have less than $1 million worth of claims, of course, each one of them will get $12,500 as a priority unsecured claim. If you're owed more than that, say you're owed $20,000, the remaining $7,500 is a regular unsecured claim, and you're going to share pro rata in the remaining dollars with everybody else, okay? The second type of bankruptcy is called a Chapter 11, and it's a reorganization. That's better news. It's better news, first of all, because most companies, if they're going to stay in business, need sales reps to continue to fill the gas tank with orders. So the result is they may deem your services essential, and any services that you provide or commissions that you provide post-petition, meaning after they file, are not subject to their bankruptcy, meaning you will get paid commissions for those orders. So a lot of questions I get is, should I continue to work for a company that's in bankruptcy? They were a really good line. I made a fair amount of money, and if they could just get out from underneath this bank debt, they might actually have something. Should I continue to work for them? But boy, I'm getting burned on all the commissions that they owe me stretching back from last season. The answer is, you might want to consider it. And the reason being that your ongoing commissions for new business is post-petition and not part of their bankruptcy. So you're not going to get washed out on your future work, okay? That's bankruptcy. Sure. His question was, I got a check before they filed bankruptcy. They filed bankruptcy a month later, and later on, I got a call from the trustee saying, I want that money back. This is the most vexing thing about bankruptcy for lay people to understand, and it's called the preference period. Under the bankruptcy laws, a trustee or a creditors committee in bankruptcy, in a reorganization, has the statutory right to wind the clock back 90 days. So the look back period is 90 days. If you get a commission check during that 90-day window, the 90 days before they file bankruptcy, you're going to get a letter from a U.S. trustee or a law firm saying, we want that money back, because it's part of the money that they bring into the estate, that they shovel into the estate to then dole out to everybody on a pro rata basis. It's meant to prevent a debtor from saying, oh, my cousin lent me $50,000. I'm going to pay him first. Or an insider saying, I lent the company 100 grand. Well, there's 100 grand left. I'm going to take that and see the rest of you later. The look back period for insiders is a year. For everybody else, it's 90 days. This is a very real problem. So to let you know what kind of a real problem this is, I have a very good client who is running a division of Hart Schaffner Marks, of Hart Marks. And he was running a t-shirt division for them. And he was doing the graphics, he was doing some of the sourcing, he was doing all the sales, marketing, promotion, the whole thing. He was running the whole division. Hart Schaffner and Marks owed him approximately $500,000 under their agreement for work that he'd done and product that he placed, some of which was sales commission, some of which was, for services. They sent him that money, and within 2 months they filed a bankruptcy, okay? He was not aware of this look-back period, so he paid his employees, he paid his graphic artists, he paid his overdue rent, he paid off his Amex card, which was huge. A year later, he gets a letter from a United States trustee telling him that he owes the estate $500,000, and if he doesn't pay it, they will sue him. That money, I'm going to use his words, that money was beer and pizza. It was gone. How am I going to pay $500,000 that I don't have? Now, I'm not going to bore you with how we got him out of it, but we did. But my point to you is, if you're dealing with a company that is teetering on financial insolvency, and you get that check in the mail and you open, you go, oh, hallelujah, thank God, you're not out of the woods. Understand, by all means, go deposit that check. Go put it in your bank account. Just remember, you might have to pay it back, okay? How I got him out of it was this. I told them that that entire amount was unpaid commissions. It was subject to an Ohio statute, which meant that it was subject to trebling as unpaid commissions under the Ohio law, and the estate would owe my client more if he made a claim for $1.5 million than if they just let him keep the $500,000. And after a lot of hemming and hawing and, gnashing of teeth, they said, we'll take 20 grand. But the 90 days deals with checks, okay? It's not when your order was written. If you received a check within 90 days before the filing of a bankruptcy, you're subject to the look back. The argument that preference is a payment during the 90 days on an antecedent debt. If the course of dealing has been that you place orders, but you don't get paid until the month after shipment, that's an antecedent debt. If they owed you in April and they were paying you in November, that's a payment on an antecedent debt. But here's what you should know about Minnesota. If you have a fair amount of business in Minnesota, you may consider, in order to avail yourself of the significant protections of our statute, you might want to think about incorporating your business in Minnesota. Then you avoid this whole thing about, gee, I'm a Chicago rep, but my territory is here, includes Minnesota, so technically under the language of the statute I'm covered. But then you have a Minnesota statute that's regulating a business relationship between two non-Minnesotans. My Miranda warning to all my good Chicago clients is, that's probably not constitutional, or there's a constitutional problem with it about the extraterritorial application of our laws. If you incorporate your business here, your corporation, your business becomes a Minnesota citizen. My feeling is then that problem goes away. And here's why. Why does every Fortune 500 company in America incorporate in the state of Delaware? Because Delaware has the most flexible, the most business-friendly corporate governance statutes in the United States. Does Shell or Mobil Oil Company have an office in Wilmington, Delaware? Heck no. Heck no. My feeling is what's good for Texaco or Shell is good for my rep clients. The only also a little disclaimer that I'll give you is talk to your CPA about it, because you're going to have to file a Minnesota tax return. It may have zeros on it in terms of income, but I don't give tax advice. So check with your CPA before you do something like that.
Are the Minnesota laws better than the Illinois laws?
Significantly. The Illinois statute is not a bad statute, but your courts have done everything they can to narrow its applicability and its focus. It's virtually impossible to get a penalty for unpaid commissions under the Illinois statute because of your courts, not because of your legislature. So in order to avail yourself of the significant protections of Minnesota law, which give you territorial rights, think about incorporating here. It might not be a bad idea.